Hey everyone, it's Rob Ryder. It's April 15th, 2014. I believe that would make it tax day today. For those who still pay those, keep in mind, IRS Manual 6209, Section 2, IRS 6209, Section 2. Go look at it. All those forms that you're going to get for your taxes, or that you should have used for your taxes, are all going to say they're for Class 5 taxes, which are gift or estate, which means you shouldn't have wrote it down as income. Yeah, so, but that isn't what this call is about. It's just to point out where we are in the year. What this call is about is, or this video, a week or so ago I did a video on the Civil Rights Act of 1866 and the incorporated by reference other acts that give the vindication for the protection of all persons. Now, of course, you're not a person, but you have a person. You actually have two persons. You got a natural person, your animal, and you have a legal person, artificial person, a piece of paper with your all capital letter name on it. It's the name of your business. Those are your persons. They're yours, and they have protection for them and a way for you to vindicate them. So this act was from 1866, which of course is right after the Civil War. Or was it? Did the war ever end? Was there ever a peace treaty signed? If not, then the current rebellion that's referenced in another act that's in this is still in force, and because of that it gives you certain remedies that you should be able to use to get a remedy from the federal government if you can't get it from the state government. Okay, that's what we started with, and then over the week, with leaving it at that to go research that a little bit deeper, to this here, where this is a letter you will get email back from the International Criminal Court if you send them an information about something they might have jurisdiction of. Apparently what they do is they send this to you and then you resend it again to make sure, I guess, that you wanted to send it there in the first place, that somebody just isn't harvesting email addresses or something. But because I tried to submit a information and I got this back, and they said if I had an information then to go ahead and send it, but they're saying to send it back to the same address, so man, they got it twice now. But this International Criminal Court was set up in 2002, and under this thing called the Roman Statute, of which 122 countries of 190 have signed on to. The United States is not one of them, but the UK is, or Britain is, I believe. Anyways, 122 out of 190 have signed on to this treaty for the International Criminal Court, and giving it jurisdiction in certain matters. Now, even states that aren't a party doesn't mean they won't agree with a private contract, right? So I'm sure that somehow the United States has agreed to this, although not agreeing on the treaty. But so what this does is this court is set up for a specific purpose of investigating and prosecuting crimes against humanity, genocide, things like that. And so some of the things it lists, and we just go down here to, what do we got? The court may exercise its function and powers as provided on the statute on the territory of any state party and by special agreement on the territory of any other state. So they don't have to have signed to have an agreement to allow them to have jurisdiction. And they're supposed to enforce the law if this nation cannot or will not enforce its human rights. Crime of genocide, crime against humanity, war crimes, crime of aggression. That's the jurisdiction of this court. And genocide is pretty self-explanatory. But to destroy in whole or in part a national, ethnic, racial, or religious group. Deliberately inflicting on the group conditions of life calculated to bring about physical destruction in whole or in part. Well, I could say that's what a chemtrail's doing. It's genocide. And I want to charge somebody with genocide for the chemtrails, but who am I going to charge? And then who's going to enforce the law? But they have this prosecutor that can investigate any case, and the prosecutor has total independence. They don't take their orders from anybody on what they're going to prosecute. And they have these crimes against humanity, such as murder, enslavement, and that enslavement is said, oh, well, that's interesting because this is talking about slavery in this Civil Rights Act. And this court has jurisdiction over enslavement. Imprisonment or other severe deprivation of physical liberty in violation of fundamental laws of international law. You don't have to be in a prison to be in prison. It's a prison planet. You're walking around on it right now. Deprivation of physical liberty. Right? You can't go any place you want to. They won't let you. They won't let you cross the border. They won't let you get on an airplane. They have all these things you can't do. Right? So, yeah, it could be considered imprisonment. If in a gaol, G-O-A-L, gaol, I think it is, jail system, you're not actually in a jail. You're just in the surrounding area of a building that's called the jail. Welcome to America. Persecution against any identifiable group, collective or political, racial, national, ethnic, cultural, religious, gender, as defined in paragraph 3, blah, blah, blah. And the Pope just said to President Obama that, he needs to be more tolerant of religious freedom within America. Well, who do you think he's talking about, right? The freedom of the Christians within America, which is being trampled on. And here's my favorite, enforced disappearance of persons. That's considered a crime against humanity. And I'm going to say you can do this enforced disappearance of persons by claiming that somebody's a decedent. And they do that quite often. They've made you disappear, right? If you're gone for 7 years, now we can say you're presumed dead and call you a decedent. In fact, it has in here, where is that? Enforced disappearance of persons. Means the arrest, detention, or abduction of persons by or with the authorization, support, or acquiescence of a state or a political organization. Don't need to be the state. Could be the Republicans, the neo-conservatives, whatever the organization is, a political organization, followed by a refusal to acknowledge the deprivation of freedom or to give information on the fate or whereabouts of those persons with the intention of removing them from the protection of law for a prolonged period of time. I'm going to say that's what's happening right now. So I decided, well, hell, I'm going to write these guys, I'm going to point out some civil rights violations, starting with the fact that, and this is based on the videos on It's All About Elections, that, these people in your state government, at least county level, the ones we deal with, the county, nobody is elected. They haven't followed any of the rules, the laws that are set up, election laws or whatever laws you want to look at, for them to say they can claim the office. So they're not holding the office. It means they've usurped the office. And they're using color of law against you, and that's what this is. The Civil Rights Act in Section 2, it's all about that any person who under color of law, statute, ordinance, regulation, or custom shall subject or cause to be subjected any inhabitant or state or territory to the deprivation of any right secured or protected by this act by use of color of law. They're saying that is shall be punished with a fine not to exceed $1,000 and imprisonment not exceeding 1 year, or both at the discretion of the court. It's a crime to do this, period. It goes on to say that in America, then the District Court of the United States is supposed to have jurisdiction over this, right? So the subject matter jurisdiction was given by the Congress in this act to the District Courts of the United States. There's no denying that they're supposed to have the jurisdiction in this matter. And so there still may be a way to do this through the federal side. In fact, we're investigating it right now. But when I saw that, well, shit, I can go ahead and use this Roman statute, go to this International Criminal Court's website, write up an information, what's going on, and send it to them, I'll go ahead and do that. So they have it now, and in the meantime, we're going to go back and kind of go through the steps of what we still need to look at on the federal side so that if necessary, we can give the information to the International Criminal Court that, hey, here's the answers we've gotten from the feds. Not only is here the evidence that the locals aren't holding the office, and it's the national government's job, their civic duty, their civil duty, to come and enforce the law, that they're refusing to do it because the Congress gave the district courts of the United States the jurisdiction over matters to do with color of law. Well, we should try to use that. Cognizance of crimes and offenses committed against the provisions of this act affecting persons who are denied or cannot enforce in the courts, judicial tribunals of the state or locality where they may be any of the rights secured to them in the first section of this act. Right? And the first section of the act listed what they were. To make and enforce contracts, to sue, be parties, to give evidence, to inherit, purchase, lease, sell, hold, convey real or personal property. And what we're trying to do right now is give them evidence of federal crimes being committed at the state level by usurpers of offices who aren't really holding the office but are still taking people's property. That's just RICO, man. That's a crime. In fact, back to the Pope, the only group I've ever heard him say this to, and it really, when you think about it, it's quite powerful. He said the mafia, organized crime, is the only group I've heard him so far said, if you don't change your ways, you are going to hell. He didn't say that about the gays. He didn't say that about atheists even. He said as long as the atheist is following his conscience, and his conscience is, a good conscience, it's up to God if he's going to accept them or not. Who is he to judge? But he did tell the mafia, said if you don't change your ways, you are going to hell. Well, that's what we're dealing with in all these courts, because none of these people are holding the office, right? So it's just organized crime. I don't care that they call themselves a judge or a clerk, or they're supposed to be the high and mighty of our society. They're a bunch of fucking crooks. Evil bastards. So anyways, this act goes on, and then it gets to this thing, well, okay, where's the remedy? Because it talks about vindicating your rights, and the remedy is in another act that's here just by reference. Incorporated by reference. Act relating to habeas corpus and regulating judicial proceedings in certain cases. Approved March 3, 1863. All right, so if we go down further, we will see that, and I did all this on the video on this subject, so I'm not doing the whole thing again, but I do want to get to what you're supposed to do. Right, because this is 1863, and it talks about during the ongoing rebellion. An act by the Senate representing the United States that during the present rebellion, the President of the United States, whenever in his judgment, public safety may require it, blah, 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 blah. Question is, are we still in the current rebellion? Well, there's never been a peace treaty, so yes, you are in the same rebellion. And it talks about they can discontinue habeas corpus, but if they do that, then there's supposed to be the certificate from the President of the United States to hold the prisoner. And so you should be asking them for a certificate to hold the prisoner instead of trying to put in a habeas corpus to get the prisoner. It could have been suspended. And also they're supposed to have furnished the circuit and district courts. Now again, this is written 1863 when there were circuit courts and district courts. The circuit court was whenever a circuit court judge and a district court judge sat together in a court, wherever that was the circuit court. Go figure. Right? They use circuit court and district court for lots of different meanings. But basically, the way it is now, the district court is the trial court and the circuit court is the appeals court. So they were going to furnish to the, let's say, the district court, the trial courts of the United States and the District of Columbia, a list of names of all state or political prisoners. You very well could be one. And then it goes on to say, that if, and in all cases, a grand jury having attended any said court having jurisdiction in the premise, after the passage of this act and after the furnishing of said list, as foresaid, has terminated its session without finding an indictment or presentment or other proceeding against any such person, it shall be the duty of the judge of said court forthwith to make an order that any such prisoner desiring a discharge from imprisonment should be brought before him to be discharged. We're state prisoners or political prisoners, or we could be. And if we went to the district court judge, the Article 3 judge, the guy that has a lifetime appointment, and so we want to be discharged per the Act of 1863 for the ongoing rebellion, because we're not at war with the United States, hell, I'll take an oath to it. Provided, however, that no person shall be discharged by virtue of this provision or this act until after he or she have taken an oath of allegiance to the government of the United States. So you're going to get discharged, take an oath to the government, and you're going to enter a recognizance, which basically means you're going to give a bond, probably pay the $10 that's due. Right? Then you're going to be released from this list and no longer a prisoner of the state. You will no longer be under detention. It's a possibility. But it goes further. If you're in a court case right now, civil or criminal in the state, what you are supposed to do is that if any suit or prosecution, civil or criminal, has been or shall be commenced in any state court against the officer, civilian or military, or against any other person, for any arrest or imprisonment made or the trespasses or wrongs done, blah, 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 right? You're going to file a petition stating the facts and verified by affidavit for the removal of the cause to the trial at the next Circuit Court of the United States to be holden in the district where the suit is pending, and offer good and sufficient surety for his filing in such court, blah, 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 blah. It starts with you putting a petition into your court case at the state level to have it removed to the next district court. I guess I'd write it just like it says here and say, per whatever the name of this act is, of whatever year it is, section whatever it is, blah, 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 see attached, I want to have this case removed to the federal court because this court is using color of law against a living man, and that is a civil rights violation. I was talking to a guy last night that here just last week, he was in a traffic situation, and he's been in quite a few of them. As it turns out, he drives without a driver's license. And sometimes it's almost like he's being profiled. But he told the judge that, if the judge didn't produce his accuser, he was going to remove this case to an Article 3 court. And the judge said, "Are you going to do that?" He said, "Yes, I am," or something to that effect. And the judge looked at the prosecutor, whatever you would call him, and said, "Well, unless the prosecution has any objections, I'm going to dismiss this case." Prosecution didn't say anything, and the case got dismissed. He said a lot of things, but the last thing he said just before that was that he was going, if they didn't produce his accuser, he was going to remove this case to a Article 3 court. Well, now he has in his mind that it's the international court, which I'm not saying it isn't, but I do know that the District Court of the United States, any district judge that has a lifetime appointment is an Article 3 judge. That's how you tell an Article 3 judge. They have a lifetime appointment from the president. So anyways, if you do this, it shall be the duty of the state court to accept the surety and proceed no further in the cause or prosecution. It's going to the federal court. And then it shall be the duty of the person taking such appeal. So like you're going to be giving this to the clerk, I would guess, right? Do you do it like a motion? I don't know. Go ask them. Let's go give it to them and see what they say. And it shall be the duty of the person taking such appeal, let's say it is the clerk of the court, to produce and file in said circuit court attested copies of the process proceedings, judgments in such cause. And you're going to be bitching about color of law, and they're going to provide the frickin' attested document to the fact that it is color of law. And the said circuit court shall thereupon proceed to try and determine the facts and law in such action, in the same manner as if it had been there originally commenced, and the judgment is such in such case notwithstanding. In other words, we're going to take this case that was being tried apparently in a state court under state law, although it really isn't, to a federal court under federal law where it really will be. And one of the things that happens in that is, in the state court from which any such action, civil or criminal, may be removed or transferred, as aforesaid, upon the parties giving good and sufficient security for the prosecution thereof, shall allow the same to be removed and transferred and proceed no further in the case. Provided, however, that if the party aforesaid shall fail duly to enter the removal and transfer, right, to put the fucking petition in, as foresaid, in the Circuit Court of the United States, agreeable to this act, the state court by which judgment shall have been rendered and from which the transfer and removal shall have been made, as foresaid, shall be authorized on motion for that purpose to issue execution and to carry into effect any such judgment, blah, 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 blah. If you don't do your duty and have it duly removed and entered into the other court, then the state can go ahead and render the verdict they came out with. But if you do, and if any suit thereafter or hereafter commenced, the plaintiff is non-suited or judgment passes against him, the defendant shall recover double cost. So you're still going to be the defendant, you're just going to have a different court trying the case. Because you can't get a fair hearing in the state court, and as long as the rebellion's still going, we can use this act. Okay, so, yeah, that's good. Now, real quick on the district courts, right? The United States district courts are the general trial courts. Courts which is a court of law, equity, and amity. And this is the thing, right? This court has 3 jurisdictions, and the one they're trying to keep us out of is equity by going to the court of chancery. Court of law can only give you a money damage, and I believe that's a Title 42 civil action, which you can do at the court. Admiralty is, that's the court of the traders, man. It's the harbor court. You don't have a license to practice there. We're not trying to practice law or be involved in commerce law. And we're not looking for damages, necessarily. We're looking for justice, and that's what equity is. And so this is the difference, right? If you wanted to put in a criminal complaint, they want you to go to the U.S. attorney and give it to him, and he'll go give it to the magistrate judge. Instead of doing what the law says, which is you should take your complaint and go to the magistrate judge, and he should sign it. It doesn't say anything about going to see the attorney. It says, right on the form, you take it to the magistrate judge. Then you read the law, it says to the magistrate judge or other judicial officer, such as, and a list a bunch of them. Never talks about the U.S. attorney. Yet when you call there, that's where they want you to go. They're trying to get you to go into the executive branch instead of the judicial branch of the government. And then the executive branch will take it over and it'll be in an administrative hearing instead of an Article 3 court. So, anyways, they got 3 jurisdictions. The district courts were established by Congress. Okay, Article 3 of the Constitution provides judicial power of the United States shall be vested in, right, the Supreme Court, and such inferior courts as Congress may from time to time ordain and establish. So they were ordained by Congress, and it made them the Article 3 courts. And then these other ones, there is at least one judicial district for each state. They all exercise jurisdiction of Article 3 court. One judicial district for each state. Now, in Michigan, we have a district called the FBI calls it the District of Detroit. And you look at it, it's a map of all of Michigan. Catholic Church calls it the Province of Detroit. You look at it, it's a map of Michigan. Okay, so what do we got here? Other federal, okay, the United States District Court is officially titled the U.S. District Judge, right? So that's the judge of the District Court. Other federal judges include Circuit and Supreme Court, which can also sit in the District Court. Federal judges are Article 3 judges appointed for life. Federal district judges are Article 3 judges appointed for life, right? You're looking for the guy that's appointed for life. He's the federal district judge. And we're looking for the district judge. We call the United States District Judge. Right? Appointed for life. Okay. Anyways, there's 678 of them. Article 3 judges floating around somewhere. And then they have these guys called the magistrate judge that works for him. And this magistrate judge, he's wearing two hats. He's a magistrate or a judge. He's either there to execute orders or he's there to enforce the, to determine the law. And so when you try to go to find a magistrate judge, they don't want you to take it to the magistrate judge. And now the game gets played because it says in the magistrate judges, do I have that on here? U.S. Marshal, Inspector General. Yeah. 28 U.S.C. 631 and on talks about the Magistrate Judge Act. That's what this is. And so if you were to read this act, you would see where it says eventually, and I don't know if I want to go trying to find it all, but they can have part-time. Magistrate judge may hold no other civil or military office or employment under the United States, provided, however, that with approval of conference, a part-time referee in bankruptcy or clerk or deputy clerk of the United States may be appointed and serve as a part-time United States magistrate judge. So there's a good chance that the clerk or deputy clerk is a part-time magistrate judge. And the way you find out is you ask them, do you have the powers of magistrate judge to take this complaint where it says here to bring it before a magistrate judge? I don't want to take it to the U.S. attorney. I want to bring it to the magistrate judge the way it says to do in the federal rules of criminal proceedings, or whatever the term of it is. Yeah, well, you can point to it. Rule 3 talks about what a complaint is. Yeah, we'll look at that in a minute. All right, so there could be these part-time magistrate judges, but when you start talking to them, they say, we don't have that anymore. They don't do that because they were supposed to have been appointed by the district court judge. So, it's like, shit, well, where are these people? Well, then you find out, you got the thing called the Office of the U.S. Marshal. They were limited to a 4-year renewable term, serving at the pleasure of the president. Oh, so they were appointed by the president. And what do they do? Register enemy aliens in a time of war. Go figure. They were law enforcers and also administrators. For the American people, the marshals personify the authority of the federal government in their communities. All right? So we're trying to find the guy that can enforce the federal law within our communities. The marshal, in effect, was the point of contact in the friction between national and local communities. State and local governments also took umbrage at federal measures. Yeah, if you had a chance to talk to like a sergeant at a police department, he'd say, state law is over federal law. He might actually tell you also he doesn't believe in God. That's what one told Roe. I don't believe in God. And he's a sergeant on a police force. Well, you don't have any jurisdiction over me, man. You don't believe in God. That makes you an enemy of God. And so what kind of powers this guy got? Well, the marshal, after taking down the names of the militiamen, returned to the courthouse where he promptly called the Secretary of State for permission to raise a posse of 2,000 men. So what kind of power the marshal has? He can raise posses. civilian enforcers. The marshals served an extremely important function. They were the barrier between civil government and military rule. They were the civilian enforcers of the law. Well, where are these people? Because they're hard to find. When you call the marshal and talk about bringing your complaint to him, he's going to tell you, well, take it to the police, which is what Roe did. And she got a chance to talk to the sergeant of the police department, and you find out right away that's a big boondoggle. Right? But see, you're not actually talking to your marshal. You're talking to a chief marshal's office, because these marshals should be within your counties. Throughout, the marshals remain essentially a local organization within a federal framework. Few people disputed the marshals' right to arrest mail robbers, counterfeiters, or others who broke federal laws. Well, there you go. I want to point out some federal laws that would be broken, like 18 U.S.C. 242, using color of law against a living man. That would be a civil rights violation. So we didn't get very far with the marshals so far, but what we did find is the marshals retain the broadest jurisdiction and authority of all the. It's one of the few agencies that comes out of the original Judiciary Act. Marshals provided the only nationwide civil police power available to the President, Congress, and the courts. They're the instruments of civil authority. Well, that's what we're looking for, the civil authority. Carry out all lawful orders issued by judges, Congress, or the President. Right? So if the President says, well, you're going to be a part-time magistrate judge and someone brings a complaint to you, it's your job to take the complaint, take their oath or whatever, well, then that's what they would do. No agency was established or designated to represent the federal government's interest at the local level. That was the problem to start with. Supplying names, registering enemy, aliens for the people the marshal personified, the federal government within their communities. The marshal, in effect, was a point of contact in friction between the national government and the local communities. Right? Certain places have, by legislation, specific, well-defined duties and jurisdictions. The marshals are not. They don't have that. Marshals personify an authority of federal government within their communities. Okay, so because the marshals enforce the laws in the local area, there's a thing in here that says they have the same powers in federal law as the sheriff has in state law. So at the Pentagon in 1967, anti-Vietnam War demonstrators confronted a thin single file line of marshals blocking their path to the Defense Department. Behind the marshals and clearly supplying the government muscle stood large numbers of regular Army troops. Standing between the rioters and the Army, the marshals symbolized the civil power of the government, which, when overcome, allowed the Army to step into the fray. Those guys out in Montana might find that out here real soon. Wherever it is, they're having their little Nevada, maybe, land dispute. And, okay. So, I just was hoping to find that one line, but I don't know where it is. Oh, here we go. Nope, that ain't that. I guess you're just going to have to take my word for it. But it comes out of the Judiciary Act of 1789. And to execute throughout the district all lawful precepts directed to him and issued under the authority of the United States, and he shall have power to command all necessary assistance in execution of his duty. Issued under the authority of the United States. So again, what's the definition of the United States? There have been Supreme Court justices that say the United States is you. You are a United State. Okay, well, I want to give him a complaint issued under me to him, giving him probable cause and some evidence to go look, investigate if this federal crime's been committed. Well, right? So the federal government doesn't appear like they want to play so far, which is one reason I went to the international site. But then Roe pointed this out to me, that there's a thing called the U.S. Office of Inspector General. There was an amendment to the IG Act of 1978, Section E. Most presidentially appointed IG special agents have had full law enforcement authority to carry firearms, make arrests, and execute search warrants. So, it used to be, so prior to this, most presidentially appointed IG and some designated IG special agents had the equivalent law enforcement authorities as a result of other statutes or annually required deputization by the U.S. Marshal Service. Okay, so now they're no longer being deputized by the U.S. Marshals. They just get the power because they made a change to the act. And now they have this full law enforcement power, and one of those powers, as we'll see in a minute, but in the United States, an Office of Emergency Management, alternatively called Emergency Management Office in some areas, is an agency of local, state, and national level that holds responsibility and comprehensive planning for and responsibility to all manners of disasters, whether man-made or natural. Well, if there's no civil authority local, that's a man-made disaster. God had nothing to do with that. That's something some man wanted to happen, and that's why it's done. But in the Section 6, when they changed it, they made it so we can have access to all records. That he can go get a subpoena, provided that procedures other than a subpoena shall be used by the Inspector General to obtain documents, information from federal agencies. You know, he can use whatever other powers he has to administer or take from any person an oath, affirmation, or affidavit whenever necessary in the performance of functions assigned by this act. Well, there you go. That's why you can take in your criminal complaint. You're pointing out that a crime's been committed. And it's his duty to take your oath or affirmation. And that's what this criminal complaint ends up being, is you're just swearing to something under oath that you believe that this act has happened, this crime has happened. So we have these guys that are called Inspector Generals, and these Inspector Generals have special agents, and these special agents, if they were appointed by the President of the United States, could have, and probably do have, these full powers. And one of them is the Inspector General's Office of the Emergency Manager. I think that was in here, yeah. So, I mean, here's a list of Inspector General's offices that, because of who they were, they didn't have to apply with some other provision that was up here further, right? And it just, you know, it names the kind of places you would think of: Department of Commerce, Education, Energy, Health, Human Services, Homeland Security. Right? All these places have Inspector Generals. Well, one of them is the Federal Emergency Management Agency. Right? So they have an Inspector General. In FEMA, well, I don't know that they would call the Emergency Manager's Office FEMA. The guy that's sitting there has the power as the civil authority to call it the military. Well, that's really a power of the marshal, right? He was the guy that could go call it a 2,000-man posse. Well, now this guy can do it. And whoever we're looking for has the same powers in the county in federal law as the sheriff has in state law. Well, the sheriff can call out the posse comitatus, right? So what's the equivalent of that in the federal law? That's what this guy can call it, the militia. You can call it the frickin' not reserve troops, right? Active duty troops. So my point is, we may find that our local representative that can take our complaint without going to the United States Attorney's Office, and we don't want to go there. I think, well, I know what we want to do is get it into the Article 3 court, and that's what we need to tell these guys. So I don't want this to go to the administrative hearing. This is for an Article 3 judge, and I need to give it to a magistrate judge. And you have the powers of a magistrate judge to take my complaint. Do you not? Yes or no? Right? Do you have the powers to take my my oath or affirmation? Because I have one to give you. To administer or take from any person an oath, affirmation, or affidavit. So, okay. So we're, now all that's done on. Yeah, I gotta go find it. Hang on a second. Okay, here's a AO 91 form. This is the criminal complaint, federal criminal complaint, and right, I don't know that I fill this top part out. See, this is what they want to do. When you go to the U.S. Attorney and put your complaint in, when he does his thing with this, and he'll be the one that signs off and takes it to the judge for this judge's signature down here. He'll be the complainant. I mean, I was told this a couple years ago, that when I called asking about this form, that the U.S. Attorney said, well, that's a form that I use. Which, is not a lie. He does use it. It's just concealment, which is the same as a lie. Shame on you. Right? Because he didn't tell me the whole truth. He only told me a partial truth. That's what Satan's best at. It's the partial truth. But if he does it, then it's going to be prosecuted in the name of the federal government and its sovereign capacity, which is the United States of America. Now, that's fine that the United States of America is on there, but you should be on there also, because you're a private citizen. And the Article 3 courts are really for private citizen concerns, not public. If it's something that was given to you by Congress, that's what the administrative courts are for. But if it's private, it's Article 3. Difference between public and private. So I would just fill this part out, right? I guess I'd leave that there and write your name in. I guess what I would do. I write my name in. I'm not going to put the defendant yet because I don't know who it is. But I, the complainant, in this case, blah, 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 right? You're going to put whatever the name of whenever the date was, whatever county you're in, the district. So for me, it would be Kent, the county of Kent, in the Western District of Michigan. The defendant violated 18 U.S.C. 242, and whatever the offense description is, I can't remember what it is. It has to do with color of law. But I might also write down here the Civil Rights Act of 1866. And the same thing. The criminal complaint is based on these facts. They took my property and none of these people are holding office. Right? I've been subjected to a simulated legal process, which is defined as color of law under the Civil Rights Act of 1866, and that's a crime. Please investigate. Right? Complaint signature, printed name, title, sworn to before me and signed in my presence, right? And this is where this judge's signature, this is where they want you to go to a magistrate judge. But, we're going to read other places where you don't need to go to a magistrate judge, but that's where you should go to, magistrate judge. Because here in the Federal Rules of Criminal Procedure, it's quite a ways down here before you get to anything. I mean, in an 84-page PDF, they don't even start talking about it until almost page 20. But Rule 3, the complaint. The complaint. The complaint is a written statement of the essential facts constituting the offense charged. It must be made under oath before a magistrate judge, or if none is reasonably available, before a state or local judicial officer. Okay? It didn't say anything about going to the Attorney General or going to the U.S. Attorney. And then, it doesn't say to go to the marshal either. It says go to a magistrate judge, but there can be part-time magistrate judges or state or local judicial officers, and one of those is a mayor. Let's see here. There's one that has it. Judge. Magistrate judge. Where are you? All right. Okay. Elsewhere in those federal rules of criminal procedure, it talks about 18 U.S.C. 1341. A state or local officer authorized to act under 18 U.S.C. 3041 is considered a judge. Okay, and identifies the local officials that can witness your complaint. AL 91, yep, blah, 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 and this is what it says. For any offense against the United States, the offender may, by justice or judge of the United States, or by United States magistrate judge, or by any chancellor, judge, superior, or Supreme Court, chief or first judge of the common pleas, mayor of a city, justice of the peace, or other magistrate, or any state where the offender may be found, and the expense of the United States, be arrested and imprisoned, or released as provided in 207. For any offense against the United States. Yeah, any justice or judge of the United States magistrate judge, chancellor, judge of a supreme or superior court, chief or first judge of a common pleas court, the mayor of the city, the justice of the peace, or other magistrate, or any of any state where the offender may be found. Now, what do they mean by other magistrate? I don't know that you can't just take this to a notary, but they don't say a notary. But they do say a mayor of a city, and a justice of the peace, and a judge of a circuit or superior court, a supreme or superior court. Right? All of them are places you're supposed to be able to take your complaint to. And so far, nobody's really wanted to say, hey, I'll take your complaint and do something with it. So, public rights distinction. Let's talk about this just real quick. The difference between public right and a private right. It was objected that the assessment and collection of a judicial act carried by non-judicial officers, thus invalidated and valid under Article 3. Where's the part that matters? There are matters involving public rights which may be presented in such form that the judicial power is capable of acting on them, and which are susceptible of judicial determination, but which Congress may or may not bring within the cognizance of the courts of the United States, as may deem proper. Right? Because if Congress gave the power or the right to somebody, Congress can take it away. They don't need the courts to be involved. So the Article 3 section, I think this is the part in here, that Article 1 courts may be created as special tribunals to examine and determine matters arising between the government and others, which from their nature do not require judicial determination and yet are susceptible of it. Right? It's going to go to a administrative tribunal, not to a judicial tribunal. Between the governments and others. That's why they want you to take your complaint to the U.S. Attorney so that it's coming from the government instead of from you. And then it can be an administrative hearing instead of a judicial hearing. Questions arising out of the administration of the custom and internal revenue. Other courts similar to territorial courts, such as conciliar courts, military court martials. Right? Those are variations of an administrative court. administrative tribunal could make findings of fact and render an initial decision of legal and constitutional questions, so long as there is adequate review in a constitutional court. Well, the only constitutional court's an Article 3 court, and Article 3 court has got a judge that's got a lifetime appointment. So if he isn't the one looking at your stuff, you haven't made it to the Article 3 court yet. Congress may utilize administrative decision makers in those private rights cases that arise in the context of comprehensive federal statutory scheme. Anytime they use the word scheme, that's bad news. Right? So they took what should be a private right case and they wrote a frickin' statute around it so that now they can say Congress is giving the power, basically, and so Congress can decide the power in an administrative hearing, of which Congress will set the rules for. Thus, the fact that private rights traditionally at the core of the Article 3 jurisdiction are at stake leads the court to searching inquiry as to whether Congress is encroaching inordinately on judicial function, while the coercion is not so great where public rights are involved, where the concern is not so great. Right? Anyways, this is the public rights distinction. If you put that in, I think this came off of the Cornell website. Talking about public rights, but basically it says the private rights are the basis of Article 3, and public rights are the basis of Article 1. And so if they can get it to be in the United States of America, then it's the government against somebody, and that's an Article 1 court. We don't want Article 1. We can let the government be part of the suit, but we want to be part of the suit. Now it's a private claims suit. And you want the prosecutor to be your prosecutor, and it to be prosecuted at the expense of the United States because it's their laws that were broken. Or so it seems. Anyways, that's some of the things that we're playing with. And for myself, I'm going to wait and see what happens with this court. I'm going to do a complete video on this because it's got a lot that, well, there's a lot to say about this court, to be quite honest. That if its function is that there's a national law that covers a certain crime, and the nation isn't going, and that crime happens to be considered a crime against humanity or genocide or whatever, and it's not going to be enforced by the nation, then they have the authority to enforce the national law. Well, one of the interesting things, let me just go find this thing here real quick. Okay, so one of the interesting things is this is that motu proprio that Pope Francis signed last summer. It caused quite a stir at the time on the jurisdiction and judicial authorities of Vatican City State in criminal matters. And it goes on to talk, it's the competent judicial authorities of Vatican City State shall also exercise penal jurisdiction over blah 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 any other crime whose prosecution is required by international agreement ratified by the Holy See if the perpetrator is physically present in the territory of Vatican City State and has not been extradited. But when such crimes are committed by persons referred to in paragraph 3 below in exercise of their functions. You go to paragraph 3. For the purpose of Vatican criminal law, the following persons are deemed public officials: those who serve as representatives, managers, directors, as well as other persons, even de facto managers, or exercise control over the entities directly dependent on the Holy See and listed in the Registry of Canonical Juridical Persons kept by the government of Vatican City State. And there's this thing called the Canonical Juridical Person. And if you've been baptized and been through the process, you should have one of these. And if you had one of these, a certificate would have been generated if you received the proper sacraments. And the certificate, because of these international agreements, would have been automatic or instantaneous, or whatever the proper word is, authenticated evidence to the state of your status. That you're not lost, none of the shit that they're doing, right? That you're a baptized Christian, you don't have Judeo-Christian beliefs, and you're not living out here in the world. Somebody has a complaint against you, they got to bring it to the church court, or a court that is acting under church law, and the church law says you got to swear to your crime, or you got to swear to your complaint. If you're not going to swear to it, then it didn't happen. So the Vatican is a signatory on this international criminal court system, which has jurisdiction over people being made to have disappeared. So what I think has happened is that we're not listed in this canonical juridical persons yet by the government of Vatican City State. If we were, right, that would be like your citizenship into the Holy See. And the reason we're not is, well, we're going to say it's because of a particular canon. Canon 842, a person who has not received baptism cannot validly be admitted to other sacraments. Well, that makes sense. The sacraments of baptism, confirmation, and blessed Eucharist so complement one another that all three are required for full Christian initiation. So as a Roman Catholic, as I was brought up, if you didn't receive baptism, confirmation, and the blessed Eucharist, Holy Communion, those three sacraments, you were not considered to be a full Christian initiation. An infant baptism isn't enough. You have to be confirmed, and they make you wait until you're the age of reason, age of majority. Now, age of reason, not the age of majority. Let you do it at 9. And they keep track of this stuff. Right? So, here's my baptismal certificate. What church I was in, certify that Robert Allen Rutluski, my mom and dad. That's funny, I don't have my mom's. It's Elsie Dorsey, not Elsie Rutluski. Interesting. Or Elsie Dorsey Rutluski, even. Blah, blah, blah. That's the front page, got the seal on it. But, the interesting thing is the back page. So this shows that in 1958, on the 18th day of September 1958, I was baptized. Check one box. I'm on my way to my full Christian initiation. Here's the back. Notations. First Communion is empty, but confirmation is filled. I got 2 out of 3. I can't be an Eagle Scout. I don't have my box filled here. I got to get this other badge. Well, if you grew up Catholic and went to a Catholic school, you know that, right? At least back in this time, back in the 60s, of course, you were baptized as a baby, and you received First Communion about the age of 7. I remember the haircut, man. I get a haircut, new shirt, white shirt, blue pants. Seemed to me it was a silver belt buckle. Military style belt buckle, if I'm not mistaken. One of those kind. Yeah. But it's not been annotated, right? So the sacramental record is incorrect. And because this hasn't been annotated, this box hasn't been checked in the master computer, push the button, make the wheel spin, I don't believe that, whatever the hell this thing is right here, that there's been this register of the canonical juridical person in the government of the Vatican City State. And all that it would take for that to happen is, because this is an error in the record, is to point the error out to the Pope and tell the Pope, hey, sit there in the chair, Peter, and, do an ex cathedra and, make a proclamation that says, if you have a record like this, that they've all been going to be corrected on your word, and we're all in the Holy See. Change our jurisdiction immediately. Notify the civil authority. Because that's what happens also. And the reason for that is there was this book you can get off of Google. Google churches and other religious organizations as legal persons. Right? And if you find one and it's edited by Lars Friedner, then you look at the same one I was looking at. And this talks about registering religious organizations as civil legal persons. And it was based on something that happened in Europe. They had some consortium get together in 2005, and this booklet is kind of a compilation of all these different ways that this is handled by the church in different countries in Europe. So, for instance, in one, the church or religious community submits an application to the Minister of the Interior and Administration asking him to grant legal personality to a specific institution or entity. The minister issues an ordinance published in the official journal of the Republic of Poland. So the church asks for this to be issued, and the minister issues a private ordinance and publishes it, gives public record within this official journal of the Republic of Poland. And it just gave it legal personality. If the church wants to create an additional entity that was not listed as one of the types, it was not mentioned individually, it submits an application to the Minister of Interior. This solution is generally applicable in respect to youth or charity centers. Right? To create an additional entity that was not listed as one of the types or was not mentioned individually. A baby. Boom. Issue. Give it, because your body is your church. It is a frickin' religious entity. It's interesting to note the vast majority of entities created by the ministerial regulations of the Catholic Church, ministerial regulations, were Catholic institutions whose creation was not foreseen by canon law. It does not infer any kind of discrimination, nor does it give rise to the assumption to claim that other denominations are less active. So there's 8 other denominations doing the same thing that the Catholic Church is doing, with, you know, the Catholic Church has these things they call concordants, that as a government it signs with other governments. But what this is saying is what comes in behind are all the other denominations cutting their deal based on the deal that was cut with the Catholics. A change introduced by the Concordant of 1993 that an entity created according to canon law automatically requires a legal personality in state law seemed to many to be revolutionary. But I guess it says it in that concordant. So if we can get the church to issue the paperwork from the Vatican showing that you're a full Christian initiate, that makes you a member of the church. It makes you a citizen of the Holy See. The church is merely supposed to inform the state about newly created entity. No approval is required. Just got to tell them it happened. Only denominations that have separate statutes in relation to the state have right to perform marriages. Only 11 of the 15 denominations decided to apply for this. Yeah, okay. Missing pages. The problem with these books is they don't show you everything online. They got missing pages, and there's probably some pretty good missing pages. The same denomination may be constituted by one registered national church or religious community, or by many registered local or regional churches or religious communities. So you can be a member of a church that has a national identity as an individual. You just be an individual church of the larger church. Churches, religious communities of supranational scope can set up a representative organization of the resident believers in the national territory, which shall require its own registration in the register instead of the registration of the part of the church or religious community existing on national territory. Okay, all sorts of little yoo-haws, but basically all these countries have set up, like now this is in Portugal, they've established a register of religious corporations. Religious corporations are entitled to public recognition of their collective rights and religious freedom, and have the right to be heard in representative town planning. Well, how can a church be heard unless the church can speak? Must be talking about you. The statute allows for forms of collaboration with the state which do not arise from religious liberty, but which are compatible with it and which become a constitutional requirement by the principles of equality because of the legal status of the Catholic Church. That's wonderful. You signed a treaty with them, right? If somebody signed a treaty with the church, the Catholic Church, and the Catholic Church says if they're in this book, right, they're protected by us, and the only reason we're not in the book is because a particular step hasn't been done to make you a full Christian initiate, because the Pope claims jurisdiction over all baptized people, period. If you were baptized in water in the name of the Father, Son, and Holy Spirit, you are a Catholic. If you follow the Apostles' Creed or the Nicene Creed, you're a Catholic of the Universal Church. So, got lots more to talk about, but this is just kind of an overview of, I'm at this stage now. I've sent in an information, which I'll go through in another video, and whatever evidence they want to see, and now it's with the prosecutor, and based on what it says about this International Criminal Court, if you're interested, they have numerous videos online about it, and they can make it sound really, really bad. But the people making it sound really, really bad are saying they're Americans, thinking the American system is really, really good. And if you know anything about this system, there's nothing good about it. It's all a fucking lie. It's all lie, cheat, and steal. It's a system of government set up by Freemasons. So we're going to see what the International Criminal Court has to say about crimes against humanity and making people disappear and enslavement. Because it's considered slavery to use color of law against a living man in the United States. We got a national law against it. Now, is the national government going to enforce it? If not, that's what this court's supposed to do. I mean, it's pretty simple logic. We'll see if they're going to do it, but you can't say that it doesn't say they're supposed to do it. And I should point out that they have a very extensive website, it looks like. In fact, they have a place, they call it the Case Matrix site, where you can go to, and it'll pretty much make sure you've done everything correct that you can if you have a case that's within their jurisdiction. At the time, I didn't want to take the time to do this, and I want to get an information in with just what I have, so I know I'm alive and I'm trying. And then if I need to go back and read this other stuff, I will. But my point is, they have a very extensive website of information and how the system works, and I'm going to spend some time reading it. Okay, I'm going to call that good for a video, and I hope you found it useful. We'll see ya.